Payback times.
The container ship Ardent Mariner was making her approach to berth 7, nudging through the gray morning chop with the slow, unhurried certainty of something that outweighed everything else in the harbor. I watched her from my office window, the way I'd watched 1,000 ships come in. Half attention, mostly habit, while the rest of my mind sorted through the Kellerman files spread across my desk. Tuesday mornings in Harwick Bay have their own particular smell. Diesel and low tide, and the yeasty exhaust from the cannery, 2 blocks east. I'd worked in this building for 19 years, and I still found it grounding. Salt air and paperwork, the twin pillars of my professional life. My phone buzzed against the desk. The screen said, Meridian Life, underwriting. I picked up without much thought. I place a fair amount of commercial marine business with Meridian, and their underwriters call me more often than their own mothers. Callum Bresaigh. Callum, it's Petra Holst. Sorry, to catch you first thing. Her voice had a careful quality I didn't recognize immediately. Petra is efficient, slightly brusque, not given to apologies. I wanted to call before we processed anything, because something landed on my desk this morning that I wanted to verify with you directly. I turned away from the window and sat on the edge of my desk. What's the issue? We received a beneficiary change request on your personal policy, the GS7 series, your whole life policy with us. I didn't submit a beneficiary change. A short pause. That's why I called. The request came in through a third-party submission channel, one of the broker forwarding services. It's dated Friday. On paper, it looks complete. Has your policy number, a copy of the form, but something felt off about the signature block, and I wanted to confirm directly. My brain was still running a beat behind. Who does it designate? Primary beneficiary, 100%. I heard her click through something on her end. R. Vularis. No middle initial. Relationship listed as spouse. The diesel smell from the harbor seemed to sharpen. Or maybe that was just the air going strange in my lungs. Vularis, I said. Yes. I assumed it might be a clerical error. Maybe a maiden name situation. Someone typed the wrong. Who are the current beneficiaries on that policy? Another click. You have 3 primary designees. Your daughter, Callum Bresaigh, 40%. Your sister, Colette Bresaigh Harmon, 30%. And the Harwick Bay Maritime Foundation, 30%. And this new request removes all 3. Correct. Replaces them with R. Vularis, sole primary. No contingent listed. I said nothing for a moment. Through the window, the Ardent Mariner had stopped making forward progress and was being nudged sideways by a harbor tug, a slow, impatient process. I watched it without seeing it. Callum, do you want me to reject the submission outright and flag it? Not yet. The professional in me surfaced on its own, steady as a keel. Hold it in pending status. Don't process it. Don't reject it. Don't generate any correspondence about it. Can you do that? I can hold it for 72 hours before the system flags it for escalation. That's enough time. Thank you, Petra. I mean that. I hung up and stood in my own office feeling like a man who'd stepped onto what he thought was solid dock and found it floating. Vularis. Not Bresaigh. Not the name on our marriage certificate. Not the name Renata had used in 11 years of marriage. Not the name she used on our joint checking account, or the car registration, or the Christmas card she signed with a looping, confident hand. Vularis was the name she was born with. The name she'd set aside. She told me once, because she wanted a fresh start when we married. The name I associated with a version of her that existed before I knew her. Why would Renata submit a beneficiary change request in her maiden name? I sat down in my chair. The Kellerman file was still spread across the desk, like nothing had happened. I pushed it aside and pulled open my bottom desk drawer. The past year arranged itself differently in my memory when I let it. About 8 months ago, Renata had started asking questions about my work in a way she hadn't before. Not intrusive questions. Renata was too smart for intrusive. Small questions, casual ones, dropped into the evenings the way you drop a line off a pier. What does a policy like that actually pay out? Do the big commercial ones always go through probate? If someone passes unexpectedly, how quickly does a beneficiary actually receive payment? I'd answered the way I answered most things, thoroughly, professionally, happy to be useful. I'd taken it for curiosity. Then, there were the files. Twice in the past year, I'd come home to find her in my home office at the filing cabinet. The first time she said she was looking for the homeowner's policy because she thought there might be a water leak under the guest bathroom. The second time, she said she was looking for the car insurance card. Both explanations were reasonable. Both filing cabinet drawers she'd been in contained my personal policies. And the weekend trip in March. She'd gone to see Diane Petrakis, a college friend who lived up the coast in Dunmore. 2 nights, she said. She took her own car, said it would be a nice drive. I'd worked a Saturday and taken Colette's dog for a long walk on the point and thought nothing of it, except that Renata had come back Sunday evening, quieter than she'd left. Tired from driving, she'd said. I'd made soup. I retrieved the key to the office safe. The safe is a Sentry fireproof, bolted to the floor behind a mahogany panel that matches the wainscoting. Old-fashioned for an office in the current decade. But I'd always believed in having paper. Digital records are fine until the system goes down or someone hacks a server. Paper, locked in a fireproof box. That's navigational dead reckoning. You know where you started. You know your speed and your heading. You work out where you are. I retrieved my personal policy files. The beneficiary page on the Meridian policy was dated the year I married Renata. It listed Miriam at 40%, Colette at 30%, and the Harwick Bay Maritime Foundation at 30%. I stared at that last line for a moment. The foundation had changed its legal name 3 years ago. We'd reincorporated under a slightly different structure for tax purposes. And the registered name went from Harwick Bay Maritime Foundation to Harwick Bay Maritime Heritage Foundation. I'd sat in the attorney's office and signed the reincorporation documents myself. I'd sent notices to all of our donor clients, advising them to update their beneficiary forms if they'd named us in their policies. I had never updated my own. It was exactly the kind of error I'd spent nearly 3 decades helping other people avoid. I'd given more beneficiary review speeches than I could count. I had a laminated checklist that I printed and handed to every new client. 5 times. You must update your beneficiaries. Marriage, divorce, birth of a child, death of a beneficiary, significant change in your estate plan. I gave those cards out at the Harbor Association meetings. I'd once made a harbor patrol officer pull over and take one through his truck window as a joke that wasn't entirely a joke. And here I sat, 11 years married, with a charitable designation, pointing to a legal entity that no longer existed under that name, and a trust I'd established for Miriam 2 years ago that wasn't reflected anywhere in this document. The trust. When Miriam turned 24, and it became clear she had her father's instinct for spending money on boats before she had a mooring slip to put them in, I'd worked with Dolores Finn to set up a modest spendthrift trust. The intent was that any insurance proceeds or significant gift to Miriam would flow into the trust rather than directly to her, where it would be protected from creditors and her own enthusiastic financial impulsivity. A sensible, loving structure. I'd told Miriam about it. I'd told Dolores. I had not updated a single beneficiary form to reflect it, which meant that if I died last week, 40% of $750,000, $300,000 would have gone directly to Miriam, with no trust protections whatsoever. I set the policy down on my desk and looked at the harbor. There's a particular quality of shame that a professional feels when he discovers he has failed to follow his own advice. It's not ordinary embarrassment. It's more specific, more cold, like finding a navigation error in your own chart. I picked up my phone and called Dolores. She answered on the third ring. Dolores Finn has been my attorney for 16 years, since she handled the dissolution of my first marriage with what I can only describe as surgical precision. She's 61, sharp as a marlin spike, and she listens to bad news the way a good doctor does, without reacting until she's heard all of it. Callum, what is it? I need to think aloud for a few minutes. I'll be brief. I told her about Petra's call. I told her about Vularis. I told her what I'd found in my own policy documents. I told her about the filing cabinet, the casual questions about payouts, the weekend in Dunmore. I kept my voice even and my sentences short, the way I'd learned to do when presenting risk assessments to underwriters. Facts first, conclusions after. When I finished, Dolores was quiet for a moment. Not because she was surprised. Dolores is rarely surprised, but because she was thinking. All right, she said. First, do nothing visible. Don't call Meridian back to block the change. Don't say anything to Renata. Don't move money. Don't access any joint accounts in an unusual pattern. You do anything visible right now, and you give her information she can use. Agreed. Second, I want you to have those policy documents with you, not in the house, and not accessible to her. The originals stay in your office safe. They stay there. I heard her scribbling something. Now I have a question for you. Think carefully before you answer. Go ahead. Has she ever had access to your signature stamp at work? The question landed quietly. I sat with it. I have a signature stamp. I know it's not best practice. I've been mildly self-conscious about it for years. But I handle a volume of routine correspondence that makes it practical. It's kept in my assistant Fiona's desk, under lock, and Fiona manages it. It's used for renewal notices, coverage confirmations, routine endorsements. Never for new business. Never for anything requiring a wet signature for legal purposes. Except that 6 weeks ago, Fiona had been out with a stomach bug for 2 days, and Renata had come by the office on a Tuesday. I remembered it now, a small cold memory surfacing, to drop off lunch, which she did occasionally, and I'd been on a call with Lloyd's. I'd asked her to go into Fiona's desk and get the stamp to mail a package of renewal notices I'd already reviewed and signed. I'd watched her walk toward Fiona's desk while I stayed on the phone, and I'd trusted the rest. Yes, I said. Once, about 6 weeks ago, Dolores made a sound that wasn't quite words. She was alone with it for a few minutes. Could she have made an impression of the stamp? A photo? A rubbing? I thought about Renata's methodical nature, her patience, the way she planned everything. Dinner parties, travel, home renovations, with a quiet, long-view precision that I had always admired. Yes, I said. She could have. Then we don't know yet what that stamp may have touched. Dolores's voice was careful, measured. I'm going to make some calls tomorrow morning. In the meantime, go home. Behave normally. Don't search the house. Don't look through her things tonight. Don't do anything that tells her you know. What am I looking for, Dolores? What's the shape of this? She was quiet for a moment. Callum, someone submitted a beneficiary change on your $750,000 policy in your wife's maiden name. Someone who had opportunity to access your signature stamp. That's what we know. The shape of it, She paused. The shape of it is something you've seen before in your line of work. She was right. I had. Not often, but enough. A spouse who begins. Planning for an outcome before that outcome is obvious. A beneficiary change, submitted quietly, in advance, to someone the policyholder doesn't associate with the name. A policy that would pay out if the insured were to die unexpectedly. Go home, Dolores said again. We'll talk tomorrow. I drove home the long way, around the point, past the lighthouse. The evening was gray and close, that particular October closeness that sits on the harbor like a lid. I pulled into our street and parked 30 feet short of the driveway, which I'd never done before in 11 years. Our house is an old federal style on a corner lot. White clapboard, black shutters. The kind of house that looks solid and permanent from the outside. The lights in the kitchen were on. I could see the warm rectangle of the window from where I sat. Renata was in there. I could see her moving past the window. Just a shape, just a suggestion of a person. The way you sometimes catch a vessel on the horizon and can't tell yet what it is or where it's headed. I sat in my truck for 11 minutes. I know, because I watched the clock without meaning to. The thing about dead reckoning, the actual navigation technique, not the phrase, is that it requires you to know your starting position exactly. You work forward from known facts. You account for speed and drift in the set of the current. And you hold open the possibility that your calculation is wrong, because dead reckoning accumulates error over distance. The farther you sail from your last confirmed position, the less certain you are about where you actually are. My last confirmed position was 11 years ago. A July afternoon at a Harbor View restaurant, where Renata had leaned across the table and said, in that direct way she had, that she wanted to build something. With me. A life. Not a project. Not a convenience. A life. I had believed her. I didn't go inside. I drove back to the office in the dark, past the cannery in the harbor master's building, and the slip where the ardent mariner was now fully berthed and quiet, her lines secured, her work done for the night. I let myself in through the side entrance and turned on only the lamp on my desk. I unlocked the safe, and I began to pull every document with my name on it. Policies, declarations pages, correspondence with underwriters, the trust documents for Miriam, my business partnership agreement with Lauren Caskey, who handles the commercial accounts on the fishing fleet side of our practice, 3 years of tax returns, my will, which Dolores had drafted, and which I suddenly very much wanted to read in full. I wasn't sure what I was looking for, but I'd spent 28 years in this business, learning that the paperwork tells you the truth, even when the people won't. Forms don't have feelings. Documents don't equivocate. What's written in a beneficiary box is what the policy pays, regardless of what anyone intended or promised or believed. I knew that. I'd known it longer than I'd known Renata. I spread everything across my desk under the lamp, and I began at the beginning, the way you do when you're not sure how far the error goes. The harbor was quiet outside. The tide was coming in. And somewhere in my house, in some drawer or safe or pocket I hadn't yet thought to check, my wife was holding on to evidence of a plan that had been set in motion long before I understood we were in danger. I didn't sleep at my office, though I thought about it. Around 11, I locked the safe, stacked everything I'd reviewed in a banker's box I kept for client overflow, and drove home the long way again, not because I needed the time, but because I wasn't ready to walk through that door without my face composed. Renata reads faces the way I read weather. She always had. She was already in bed when I came in, the light under the bedroom door dark. I stood in the kitchen for a while, drinking water I didn't want, listening to the house breathe around me. Old houses have sounds. This one had settled into itself over 140 years, and I knew every creak of it. The third stair from the top, the way the guest room radiator knocked at 2 in the morning, the particular sound the kitchen window made in a nor'easter. I didn't know the woman I'd been sleeping beside for 11 years. I went to bed and lay in the dark and listened to Renata breathe, slow and easy, and thought about what I knew for certain and what I only suspected. I practiced keeping those two categories rigorously separate. It's something you learn in underwriting. Suspicion is not evidence. Pattern is not proof. You build the case from what you can verify, not from what you feel. I was at my office by 6:30. The banker's box went back into the safe. The first thing I did was make a handwritten list of every financial instrument Renata and I held jointly or separately from memory. Checking accounts, savings accounts, the rental property on Gull Street, the brokerage accounts, the retirement accounts. I've always kept mental clarity about my financial picture, an occupational habit. So the list came quickly. 16 line items. The brokerage account gave me pause. I stared at it for a moment, my pen hovering. We'd opened a joint brokerage account roughly 18 months ago. Or rather, I had a dim memory of something paperwork related around that time frame. Renata had been managing the rental property more actively and had mentioned, once, needing to streamline how the rental income flowed between accounts. I remembered signing something at dinner, the kitchen table, a Tuesday evening, a glass of wine at my elbow, the television going in the background. She'd set papers in front of me and said something about refinancing the structure of the rental income tracking. And I'd read the top page and signed where she indicated. I opened my filing cabinet and looked for the brokerage account documents. I keep moderately organized personal files here, not the meticulous system Fiona maintains for client records, but functional. It took me 15 minutes to find what I was looking for. A folder labeled Joint Investment in Renata's handwriting, filed, behind the household expenses. I sat down at my desk and read every page. It was a standard brokerage account application. Our names, our tax identification numbers, joint tenancy, with right of survivorship, all normal. What was not normal was the fourth page. A supplementary beneficiary designation form, separate from the account's survivorship structure. In the event of simultaneous death or death of the surviving account holder, where do the assets go? My signature was on page 4, or something that looked like my signature. I held it at arm's length and then close, which is not a forensic methodology, but it told me something. The signature was mine, in the way that a good copy is always almost the thing it copies, a fraction more deliberate than my actual hand. My real signature moves fast and collapses on itself at the end, the H in Bresaigh becoming almost vestigial. This one completed it, and the beneficiary designated on page 4 was R. Volaris. I set the document down on the desk and looked at the harbor. The morning was brighter than yesterday, a thin winter sun on the water, the kind of light that illuminates without warming. 18 months ago, that was the brokerage account. The Meridian change request was dated last Friday. I thought about what lived between those 2 points and began, in the systematic way I'd learned to think about risk accumulation, to map the timeline. I keep a yellow legal pad for working problems. I date the top and write longhand, which forces me to slow down and think in complete thoughts. I wrote down every paperwork event I could recall Renata being involved in, directly or peripherally, going back 3 years. 3 years ago, an address change on my Anchor Mutual term policy. I'd remembered getting a confirmation in the mail and thinking we must have discussed it without my retaining it. because I do sometimes forget routine things. 2.5 years ago, a rider inquiry on the Meridian whole life. I'd gotten a voicemail from their customer service line confirming that a rider had been reviewed at my request. I'd called back and said there must be a miscommunication. The representative had apologized and said someone had called in on the account. I hadn't filed a complaint. I'd assumed it was a processing glitch. 21 months ago, a name update on a small bank savings account we kept for household expenses. The account had been temporarily listed under an alternate spelling of Renata's name, which she'd corrected in person at the branch. 18 months ago, the brokerage account and the page 4 signature. 8 months ago, I went still when I reached this one. I had a vague memory of signing a form Renata had brought home, something she'd described as an annual policy review update that her cousin's brokerage had sent, wanting to make sure all the addresses and contact information were current. I'd been tired. It had been a long week. I'd signed it at the kitchen counter while still in my coat. 8 months ago. I put the pen down and called Dolores. It's 7:15, Callum. I know. Are you somewhere you can talk? A pause. Then the sound of a door closing. Go ahead. I walked her through the timeline. Every event, every signature, every small administrative moment I could reconstruct. When I finished, the line was quiet long enough that I thought I'd lost the connection. That's signature conditioning, she said. I know what it is. I'd heard the term before. A colleague in the fraud investigation side of the industry had used it at a seminar 2 years ago. I just never expected to be the one who'd been conditioned. Most people don't. That's why it works. Her voice was measured, practical. Callum, I need you to gather every document you can find, that your signature appears on that you didn't initiate yourself. Everything Renata gave you to sign. Everything that arrived in the mail that she might have intercepted first. I also need you to compile your genuine signature samples, correspondence you originated, documents you signed in my office or in front of witnesses, for a handwriting examiner. Yes, I know someone in Providence who does forensic document work. Good reputation, admissible in state proceedings. I'll call him today. And the insurers? One step at a time. Before we contact any insurer formally, I want the forensic opinion in hand. Right now, we have Petra holding the Meridian request in pending status. How long did she give us? 72 hours from yesterday morning. Then we have until tomorrow morning. I'll file a formal written fraud objection with Meridian today. That triggers their internal fraud hold protocol. The change request gets quarantined, and their legal department takes ownership of it. It buys us significantly more time than Petra's informal hold. What does the fraud objection require? A signed letter from you, as the policy owner, stating that you did not authorize the change request and requesting a hold pending investigation. You can do that as a living policy owner. You have standing the insurer can't easily dismiss. I'll draft it this morning. I heard her scribbling. Callum, you said you had a second policy with another carrier. 2 others. The Anchor Mutual term, $200,000, and a smaller whole life with Harbor Coastal, $150,000. Call both of them. Today. Not to do anything yet, just to get a verbal account status. Ask if there have been any recent changes to the policy in the last 18 months. I'd already been thinking about this, but I'd been hoping not to have to make those calls. As long as I hadn't made them, the answer was still uncertain. All right, I said. I called Anchor Mutual first, because the term policy was the larger one. I gave the service representative my policy number and security passphrase. and asked her to confirm the current beneficiary designation and any changes in the last 24 months. She put me on hold for 4 minutes. When she came back, her voice had the careful quality of someone reading from a screen. I show a beneficiary change, processed 8 months ago, Mr. Bresaigh. The primary beneficiary was updated from 3 parties to 1. The current primary beneficiary is listed as R. Valaris, 100%. I wrote it down on my legal pad, kept my voice neutral. Thank you. Don't make any changes. I'll be in touch. So there it was. Not a single incident. A pattern. The Meridian request was the most recent move, but the Anchor Mutual change had already been completed 8 months ago, sitting quietly in their system while I went about my days, without knowing that $200,000 of my life insurance had been rerouted to a name that wasn't on my marriage certificate. I'd been living next to this for nearly a year. The Harbor Coastal policy, when I called, showed no changes. The original designation was intact. Small mercies, or perhaps she hadn't gotten to it yet. I sat for a long moment. Then I picked up the yellow pad and kept writing. The compliance specialist I called mid-morning was a woman I'd worked with tangentially over the years, Nora Vance, who'd spent 12 years on the regulatory side of a major insurer before going independent as a compliance consultant. She knew the mechanics of policy administration, the way I knew underwriting. From the inside, she listened, without interrupting. When I finished, she said, "This is more common than people think, which is the thing that should terrify everyone, and terrifies almost no one. How does an insurer process a beneficiary change without verifying identity beyond a signature? Most standard change of beneficiary forms require the policy owner's signature, the policy number, the new beneficiary's name and relationship, and a date. Some insurers require notarization. Most don't. The ones that don't are relying on the assumption that the person submitting the form is who they say they are." She paused. When someone submits through a third-party channel, a broker forwarding service, a fax, a mailed form, there's no face-to-face verification. The insurer receives a completed form with what appears to be a valid signature, a valid policy number, and they process it. So the structural vulnerability is the assumption of good faith. The structural vulnerability is the absence of identity verification at the point of submission. Yes, she sounded neither surprised nor indignant, just clinical. The insurer isn't being negligent in a legal sense. They're following industry standard practice. But industry standard practice was designed for a world where forging a signature was harder than it is now. What are my remedies once we have the forensic examination? As the living policy owner, you have the right to challenge any change made to your policy without your authorization. You file a written objection with the insurer's legal and compliance department, not customer service. You include the forensic document examiner's report. You request a formal investigation and a hold on any disbursement pending resolution. She paused. If the policy owner dies before the matter is resolved, it gets complicated. The named beneficiary can file for payment, and you're in civil litigation. But since you're alive, you have standing to compel the insurer to investigate and to freeze the designation pending the outcome. And state regulators? If the insurer doesn't respond appropriately to your fraud objection, you file a complaint with your state insurance commissioner. Documented forgery on a beneficiary form is a serious matter. The commissioner can compel the insurer to act. Nora's voice had sharpened slightly. Courts can also issue injunctions if it comes to that. preventing disbursement pending resolution of a fraud claim. But you don't want it to come to that, because by then, you're in probate territory. What would you tell someone in my position? Right now. A brief silence. I'd tell them to move quickly and methodically, get the forensic opinion, file the fraud objection with documentation, notify every insurer, not just the ones where changes have already been made, and talk to a divorce attorney, because the insurance picture doesn't exist in a vacuum from the marital estate. That afternoon, I went to see Dolores in person. Her office is on the third floor of a federal-style building, 2 blocks from the courthouse. The kind of office that smells of old briefs and radiator heat, bookshelves floor to ceiling, a window that overlooks a parking structure, but which she has never once seemed to wish were different. She handed me coffee without asking, and we sat at her work table. She walked me through what she'd filed with Meridian. A formal written fraud objection. My signature. The real one. Signed in her office with her as witness, asserting that the beneficiary change request submitted to Meridian Life Insurance Company, under my policy number, was unauthorized, that I had not signed or authorized any such submission, that I was requesting a formal hold pending investigation. They'll assign it to their Special Investigations Unit, Dolores said. Standard fraud protocol. The change request goes into a quarantine status. It can't be processed in any future. Change requests go through an enhanced review protocol. She set the letter on the table between us. I'll file the same objection with Anchor Mutual once we have the forensic samples. The change there was already completed, which is a different situation. Can we reverse a completed change? We can challenge it. If the forensic examiner confirms the signature is not yours, we have grounds to petition the insurer to rescind the change. They're not required to comply immediately, but with a forensic report and a fraud objection in hand, most insurers will voluntarily freeze the designation pending resolution, rather than face liability for paying a fraudulent beneficiary. She picked up her pen. If they don't cooperate, we seek a court order. That's why we do this in order. Build the paper record first, then compel if necessary. And she doesn't know yet that I know. Dolores looked at me steadily. No. And we'd like to keep it that way for a while longer. I also met, briefly and at Dolores's request, with a divorce attorney named Frank Carucci, whom she called as a courtesy consult. He was a compact, deliberate man who'd spent 30 years in family law and who had the permanently unsurprised expression of someone who has heard every human story at least twice. He explained the state's position on marital assets and insurance in the event of divorce, which in our jurisdiction required equitable distribution of marital property, but life insurance policies were generally treated as separate property if established before the marriage. Beneficiary designations were governed by the policy document rather than the divorce decree, unless a court order specifically addressed them. The most important thing for you to understand, he said, sitting back in his chair, is that in many states, including this one, a divorce decree does not automatically revoke a beneficiary designation on a life insurance policy. If you were to die after a divorce was filed but before the policy was updated, and the court hadn't issued a specific order addressing the policy, the named beneficiary at the time of death collects. I knew this. I told clients this. The information landed differently now that it applied to me. So the beneficiary forms are the battle, I said. The beneficiary forms are always the battle, Frank said. They supersede wills. They supersede divorce settlements. unless the settlement specifically addresses them and there's a subsequent court order. I've seen estates upended because someone updated their will but forgot the forms. I've seen ex-spouses collect $200,000 because the decedent meant to update the form after the divorce was final and died 3 weeks before they got around to it. What's my position right now? Right now, you're the living policy owner, which gives you maximum leverage. You can update your designations legitimately with documentation, and the fraudulent submissions become moot on the policies you update. On the Anchor Mutual policy, where the change was already processed, you're in a challenge posture, which your attorney is handling. The cleaner you make your own legitimate designations, and the faster you do it, the cleaner your position is if this goes to court. After I left Carucci's office, I drove back along the harbor road, window cracked despite the October cold, needing the air. The water was dark green, whitecaps running, a nor'easter building somewhere offshore. I thought about my laminated checklist. 5 times. You must update your beneficiaries. I'd made that checklist 15 years ago for a client, a widow, who'd come to me in tears because her husband had died without updating his policy after their eldest child was born. The designation still named his parents as primary beneficiaries, his parents, who were still alive, who had received the insurance proceeds legally and without any obligation to share them with his widow, and 3 children, because the form said what the form said. She'd asked me if there was anything she could do. There wasn't. The form governed. I'd gone back to my office that afternoon and made the checklist. I'd laminated it and given it to every new client for 15 years. I'd been married 11 years, and I hadn't followed my own checklist once. Renata served pasta for dinner that evening. She'd made a sauce that had been simmering since afternoon. I could smell it when I walked in. Something she knew I loved. The smell of a meal in progress when I came through the door. She had wine poured. She asked about my day, and I told her it had been routine, some underwriting calls, a file review. She told me about a neighbor who'd had a fender bender in the parking lot at the market, and I listened and made the appropriate sounds. I'd been doing this since I was a child, appearing to be present when I was somewhere else entirely. Some professional skills begin early. After dinner, while I was rinsing the plates, she appeared beside me at the kitchen counter with a manila folder. She set it down with the deliberateness of someone who'd thought about this moment. "I've been meaning to show you these," she said. Her voice was easy, warm, the voice of a woman doing something routine. I had a conversation with a financial advisor a few weeks ago, someone my friend Alana recommended, and he put together some updated estate planning documents for us, just to consolidate everything. You're always saying beneficiary paperwork is the most important thing people ignore, so I figured I'd take the initiative. She opened the folder and set it in front of me, fanned slightly so I could see it was multiple pages. Professional binding, a cover sheet with a firm name I didn't recognize, Coastal Meridian Advisory Group, a name close enough to familiar that it might not trigger scrutiny on a quick glance. I dried my hands. I looked down at the documents. I did not touch them. The cover page described them as a unified beneficiary and estate trust coordination agreement. 4 pages. I could see by the thickness of the stack. Professional formatting. The kind of document that looked like something a real financial planning firm would produce. I was aware of Renata beside me, her attention on my face, reading it the way she always read me. I made sure my face gave her the careful, mildly engaged expression of a husband whose wife has done something considerate and administrative. Where did you say you found this advisor? I asked. Casual. Through Alana. He's based in Dunmore. Dunmore, where she'd taken her weekend trip in March. He was very helpful. It's really just a formality. Consolidates everything into one structure so there's no confusion later. I lifted the first page and read it at my natural speed, moderately fast. Page 1 was a recital of our names, the policy numbers. She'd gotten the numbers right, which told me she'd had access to all of them, and a description of the trust structure. Page 2 was the assignment language. Page 3 was a signature block with 2 lines, one for each of us. I turned to page 4. Buried in the body copy, after 2 paragraphs of standard trust language, was the operative sentence. In the event of the grantor's death, all life insurance proceeds payable under the designated policies shall be distributed to Renata Vularis Bresaigh as sole trustee and sole beneficiary, without restriction or condition. All proceeds, not a portion, not a co-trustee structure, sole beneficiary, sole trustee, no contingent name. I looked up at her. I'll have Dolores review it, I said. My voice came out exactly right. Mild, untroubled. The voice of a man who was mildly inconvenienced by process. Something crossed Renata's face. So fast I might have imagined it, but I hadn't. A flicker of something that wasn't irritation exactly, more like recalibration. It's just a formality, Cal, she said. The smile stayed in place, but it stopped 2 inches short of her eyes. You don't need a lawyer for something like this. It's not a complicated document. And there it was. The thing I'd been waiting for without knowing I was waiting for it. Not the document. Not the fraud. The tell. A woman with nothing to hide would have said, "Of course. Have Dolores look it over." That's exactly what I'd expect you to say. A woman with something to hide says you don't need a lawyer for this. Renata, I run everything by Dolores. You know that. I closed the folder gently and handed it back to her. I'll take it to her tomorrow. She took it. The smile didn't waver. Of course, she said. I just thought, since it's straightforward, she'll probably have it back to me in a day, I said, and turned back to the sink and finished the dishes. We watched television afterward. She leaned against me on the couch the way she always did, and I kept my arm where she expected it. And I watched the screen and thought about page 4, and about Dolores, and about tomorrow. She went to bed at 10:15. I waited 20 minutes, sitting in the dark kitchen, listening to the nor'easter arrive in earnest outside, rain against the windows, wind moving through the eaves of the old house. Then I went to my coat where I'd left it by the door, retrieved the folder from the inner pocket, where I'd slipped it while Renata was putting the wine glasses away, and I photographed every page on my phone, with the kitchen light on overhead. Slow, flat, each page fully legible. I emailed them to Dolores at 10:44, with a single line. She gave me these tonight. Asked me to sign. Look at page 4. Asked me not to involve a lawyer. Then I went back to page 4 on my phone and looked at something I'd noticed in the room, but had kept behind my eyes until now. At the bottom of page 4, below the main signature block, was a witness attestation section. 2 lines. Name and signature of witness. The date. Someone had already signed the witness line. A name I didn't recognize. A date from 3 weeks ago. Someone had already witnessed my signature on a document I hadn't signed. I stood in my dark kitchen with the rain against the glass, and the nor'easter making the old house shudder along its bones. And I looked at that pre-signed witness line, and something in me went very quiet, not afraid, past afraid. I forwarded the photos again, this time to Dolores and to the forensic document examiner she contacted. and this time I wrote, Page 4, bottom. Witness signature predates my signature. I have not signed this document. I put my phone face down on the counter. Outside, the harbor was dark, and the nor'easter was running hard, whitecaps invisible in the black water. And somewhere out there, the ardent mariner was riding at her lines, secured, riding it out the way a well-moored ship does, taking the weather without moving. I poured a glass of water. I drank it standing at the counter. I had not signed a single thing. Dolores called me at 7:15 on a Thursday morning, 3 weeks after the dinner with the folder, and said simply, "We're ready." Those 2 words carried the weight of everything assembled in the weeks between. The forensic examiner's report ran to 11 pages and concluded with professional certainty that the signatures on 4 documents were inconsistent with my known signature samples, to a degree indicating fabrication, likely through digital reproduction or trace mechanical transfer. The fraud objections filed with Meridian and Anchor Mutual, both now formally acknowledged and under investigation by their respective special investigations units. The notification to the State Insurance Fraud Division, which had assigned an investigator named Tallow, who wore sensible shoes and asked precise questions and made me feel, for the first time in this entire ordeal, that the machinery of accountability was genuinely in motion. The divorce filing, which Frank Carucci had prepared and which sat in a sealed envelope in Dolores's office safe, ready to be served at the moment we chose. We'd agreed to do it all in one room, one morning, one conversation that Renata could not redirect, reframe, or exit gracefully. I told Renata on Wednesday evening, keeping it brief and light. Administrative thing at Meridian's regional office, I said. Some discrepancy in the address records. They want both policyholders present to confirm joint account details. She asked if it would take long. I said an hour at most. She said she'd move a hair appointment. She was dressed carefully when we arrived at the Meridian regional office on Harbor Street. She always dressed carefully. A gray wool coat, dark trousers, the pearl earrings she'd worn on our 3rd date. She looked composed and well prepared, which she was, for a completely different meeting than the one she was walking into. The conference room was on the 2nd floor, overlooking the street. When I opened the door and she walked in ahead of me, I watched the back of her neck with professional attention. Dolores was already seated at the far end of the table. Beside her sat Martin Cho from Meridian's Special Investigations Unit, a careful, gray-templed man I'd placed business with for a decade, whom I'd called directly 2 weeks ago, and who had listened without interrupting, and then said, "Callum, I've known you for 10 years. Let me make some calls." Beside Martin sat a woman introduced to me as Lynn Tallow of the State Insurance Fraud Division, the sensible shoes investigator who had a yellow legal pad in front of her and a pen already uncapped. A representative from Anchor Mutual's legal department was present by video on a screen at the head of the table. Renata stopped moving for just a fraction of a second. You'd have to know her to see it. The almost imperceptible recalibration, like a compass needle swinging to find north. Then she continued into the room with her chin level. "Renata," Dolores said pleasantly, "please sit down." She sat. I sat beside her, not across from her. I wanted to see her face and the documents on the table simultaneously. She looked at me. "Callum, what is this?" "Administrative discrepancy meeting," I said. "Just like I told you." Her eyes moved around the table, taking inventory, assessing the way she'd always done in unfamiliar rooms. "I think there's been some kind of misunderstanding," she said, addressing the group with composure that was genuinely impressive. Callum and I have been working on updating our estate plan together. If there are questions about the paperwork, I'm sure we can clear it up simply. Dolores placed 3 documents on the table and slid them toward the center. The Meridian Beneficiary Change Submission, the Anchor Mutual Change Form, the Coastal Meridian Advisory Group Estate Document with the pre-signed witness attestation visible at the bottom. Beside the documents, she placed the forensic examiner's report. These forms bear signatures purporting to be Callum's, Dolores said, in the even factual tone she uses when language should land like stone. A forensic document examiner has concluded they are fabrications. Meridian Life has issued a formal fraud hold on the change request submitted to them. Anchor Mutual is reviewing the completed change on that policy for rescission based on fraud. Renata looked at the papers for a long time. Then she looked at me. Something shifted in her face, not breaking exactly, but a settling, a final dropping of a calculation she'd been running. When she spoke, her voice had changed. The warmth was gone from it, replaced by something colder than anger. "You were always too trusting, Cal," she said. "That's not my fault. That's just who you are." The room was very quiet. Tallow's pen was still. Martin Cho looked at the table. I held her gaze and let the silence sit for a moment, because some things deserve the weight of a full breath before you answer them. "You forgot I wrote the policy," I said. She understood what I meant. I watched her understand it. Not the metaphor, the literal fact. I had spent 28 years in this industry. I had placed business with every insurer represented in this room. I had trained with the fraud investigators, served on industry panels with the regulators, referred clients to Dolores for estate planning for 16 years. Every professional in this room knew my name before they knew hers. She had studied my sentimentality about my daughter, my sister, this harbor town, and she had calculated that it made me soft. She had never studied my reach. She knew it. Now, Tallow set down her pen and introduced herself formally. She explained in measured terms that the State Insurance Fraud Division had opened an investigation and that Renata had the right to legal representation before answering any questions. Martin Cho confirmed that Meridian would cooperate fully. The Anchor Mutual representative confirmed the same on the video screen. I stood up because there was nothing more for me to do in that room. Dolores would handle what came next. That was the agreement. "Goodbye, Renata," I said. She didn't respond. She was reading the forensic report, studying the thing that had undone her, trying to find the error in it. I took the elevator down and stood on Harbor Street in the November cold for a moment. The water was visible at the end of the block, slate gray, a light chop. I put my hands in my coat pockets and breathed the salt air and let myself feel whatever was there to be felt, which turned out to be less dramatic than I'd anticipated. Not triumph, not grief, something quieter, the feeling of a problem correctly solved. Frank Carucci served the divorce papers that afternoon. In the days that followed, Dolores walked me through the legal architecture of what we'd built, and I found myself learning from the inside things I had known for decades, from the outside. "You had a safety net you didn't know about," she told me, sitting across from me at her work table, with a cup of tea she'd made but wasn't drinking. "The moment you filed for divorce, the state's automatic revocation provision kicked in." I knew the provision. I'd explained it to clients countless times. But I let her explain it to me now, because I wanted to hear it as a person, rather than a professional. In this state, when a divorce filing is made, any existing beneficiary designation naming the spouse is automatically suspended. not voided permanently, suspended, pending the final decree. If you were to die during the divorce proceedings, the suspended designation goes to the contingent beneficiary, or if there's no contingent, to your estate. Even if the designation was fraudulent, I asked. The automatic revocation doesn't care about fraud. It applies to all spousal designations uniformly. The fraud gives us the additional remedy of voiding the designations entirely and recovering the changes already made. But the revocation provision was your floor protection the moment we filed. She looked at me over her reading glasses. You'd been telling your clients about this provision for years. I had, I said. It landed differently this time. It always does. She also explained what the insurer's legal team had clarified about the scope of the court's authority in cases where fraud is proven through forensic evidence and investigation. State courts in our jurisdiction have the explicit authority to void beneficiary designations obtained through fraud or forgery, regardless of what the insurance contract itself says. The designation is treated as legally void ab initio, as if it never existed. The courts can reach into a private insurance contract and override it, I said. When the designation was obtained through fraud, yes, the contract is only as valid as the consent that created it. Forged consent is not consent. There was one more distinction that the Anchor Mutual attorney had raised during a subsequent call, which I found myself filing away with particular care. Not because it affected my situation directly, but because I knew it would come up for someone else someday. What about employer-sponsored policies? I'd asked him. The ERISA preemption question. He'd been pleased I raised it. Employer-sponsored group life insurance is governed by federal law under ERISA, not state law. That means state automatic revocation provisions, state fraud remedies, state court injunctions. None of those apply directly. The federal courts have jurisdiction, and the ERISA rules preempt state beneficiary laws. Someone with an employer-sponsored policy in a divorce situation can't rely on state automatic revocation to protect them. They'd need to update the form manually, I said. Immediately. There's no safety net. RISA plans. Honor the form on file. Period. Courts have been remarkably unsympathetic to surviving spouses who assume divorce proceedings protected them from their ex-partner's employer policy. I didn't have an employer-sponsored policy. I was self-employed, and all my coverage was individually owned. But I made a note on my yellow legal pad. EHISA, no state law safety net. Manual update required immediately. Divorce does not protect. I'd be adding that to the laminated checklist. The criminal investigation moved at its own pace, slowly and methodically, the way serious investigations do. Tallow called me twice in the first month with straightforward questions, and once to tell me they'd identified the individual who had signed the false witness attestation on the Coastal Meridian document. I didn't know the name, and told Tallow I didn't want to know more than I needed to know to cooperate fully. She said that was a reasonable position. I cooperated fully. I provided documents, signature samples, records, testimony. Then I stepped back and let the institutions do what institutions exist to do. There's a temptation, when you've been wronged, to want to drive the punishment, to push, to follow up, to be the one who ensures justice doesn't slip through the cracks. I resisted it, not out of generosity toward Renata, but because I understood that the case was stronger without my fingerprints on the prosecution strategy. I let it go. The institutions had it. The rental property on Gull Street went through asset division. Frank Carucci negotiated a clean structure. Renata received a cash settlement equal to her equity interest, and I retained the property. I signed the final property documents on a Tuesday morning in Frank's office and walked out into a cold December noon, feeling lighter than I had and longer than I could easily account for. 2 days later, I sat down with Dolores in a long afternoon, and my 4 insurance policies spread across her work table. And I did what I should have done 11 years ago. I updated every beneficiary designation properly, in sequence, with correct legal names. The Meridian whole life policy, the largest, at $750,000. I designated with Miriam's trust as primary beneficiary. Not Miriam directly, but the trust named correctly, with the trust tax identification number, exactly as Frank and Dolores had structured it for her. Protection. If I die tomorrow, those funds flow into a protected structure that Miriam can access under the terms we designed together, shielded from creditors and from her own occasional enthusiasm for expensive maritime hobbies. The Anchor Mutual Term Policy, $200,000. I designated to my sister, Colette. She called me 3 times in the weeks after everything came out, never asking questions I didn't want to answer, just calling to say she was there. She's been there for 53 of my 54 years. The designation felt right in a way that was simple and clean. The Harbor Coastal whole life, $150,000. I designated to the Harwick Bay Maritime Heritage Foundation. The correct legal name, exactly as it has been for 3 years. I had the current legal name confirmation letter from the foundation's secretary on file before I signed the form, because I was not going to make that particular error twice in one lifetime. Dolores witnessed every signature. Her assistant witnessed as backup. I left her office with certified copies of all 4 designations and originals filed in my office safe. That evening, I called Miriam. She lives up the coast, manages a small marina, has a boat she is perpetually refinishing. She knew the broad outlines of what had happened, and she reacted the way she always reacts to difficult things, by going quiet for a moment, and then asking what she could do. Nothing, I told her. I'm calling to tell you it's resolved. Are you okay, Dad? She asked. I thought about it genuinely before answering. Yes, I said. I think I actually am. She told me about the boat. I listened. And it was a good conversation. The kind where nothing important is said explicitly, but everything important is communicated. The dawn comes late in November. I was at the pier by 6:30 the next morning, earlier than the light, and I stood with a cup of coffee from the cannery cart and watched the gray begin to thin over the water. The ardent mariner was in berth again. She'd come back around. Container ships run regular routes, and Harwick Bay was one of hers. I watched her lines being cast off, one by one, the harbor tugs easing her nose around to face the channel. There's a moment when a ship stops being berthed and starts being underway. It's not the moment the engines engage or the moment the lines come off. It's a moment before that, almost a decision, a shift in the quality of the thing. The ship that had been resting becomes the ship that is going. I reached into my jacket pocket and took out a folded set of papers, 4 pages, each one a beneficiary designation form. I knew what they said without unfolding them. Meridian, Miriam's trust, primary. Colette, contingent. Anchor, mutual. Colette, primary. Miriam's trust, contingent. Harbor, coastal. Harwick Bay. Maritime Heritage Foundation, primary. The brokerage account, Miriam's trust, primary. Callum Bresaigh Revocable Living Trust. Contingent. A legitimate structure. Properly documented. Signed in front of witnesses, who were there by choice, and whose names I knew. All of it correct. All of it intentional. All of it mine. I folded the papers and put them back in my pocket. The ardent mariner had completed her turn. She was pointed at the channel now. The open water beyond the breakwater. The Atlantic beyond that. The tugs fell away, and she began to move under her own power. Slowly at first, with that unhurried certainty of something that knows exactly where it's going. I thought about what I'd built over 28 years. The clients, the relationships, the professional network that had assembled in a conference room on Harbor Street because they knew my name and trusted what it meant. I thought about Miriam and Colette and the foundation doing work worth protecting. A youth seamanship program, a harbor history, archive, a scholarship fund for the children of fishing families. I thought about the policies and forms and legal structures as mechanisms serving a single point. The people on the other side of them, the ones who get a phone call someday and find out that someone thought about them in advance, structured something carefully, made sure the right name was in the right box. I'd spent 28 years building that mechanism for other people. I'd fixed it for myself, finally, completely. The ardent mariner passed the breakwater and met the open sea, and her pace changed. The small sheltered chop of the harbor giving way to the longer roll of open water, and the ship lifting slightly and settling into it, finding the rhythm of the thing. The water was gold now, the sun above the horizon, the color running across the surface, all the way to the pier where I stood. I drank the last of my coffee. I turned up my collar against the wind and walked toward the harbor gate, toward the day that was waiting.